Belum mulai. Ini bagian dua, ini sesi dua.
Will be moderating this session today. So I'd like to thank everyone who joined us today everywhere. And I believe it's going to be a rich discussion on two big topics here, on access to justice and land conflicts in Asia. I mean, this is, of course, very important topic, especially if we look at the numbers of land conflicts in Indonesia, they are very prevalent. And if we read a newspaper, like it's very common that we have this that news coverage on land conflicts in most of the parts of Indonesia. And also the second reason is that why this important is that related with this winner collaboration between Indonesia and the Netherlands, as we know that Indonesia and the Netherlands have a long-standing cooperation in the field of rule of law and access to justice. So, and Indonesia has since 2008 has adopted a national strategy on access to justice with the aim of boosting the accessibility of its legal system. So in this panel, we want to discuss and evaluate the effectiveness of these reforms by presenting the result of various research projects in Indonesia, how Indonesian deal with legal system in Indonesia, and what are the obstacles, and how we can improve this and address the obstacles to this access to justice. And just a bit of introduction to the format of this session. This will be an hour session, and then we will have three presentations, I mean, and then one discussion, about 5 minutes each. And then we have, to make it more interesting, we will have time for all audience to ask questions and discuss, especially related to obstacles of access to justice in Indonesia. And sure, and then without further ado, I will introduce our speakers today. I mean, all of them are quite familiar for us, especially if we work on land issues in Indonesia. First, but I will introduce. First, our speaker is Pak Yance Arizona, SHMH. Hello, Pak Yance. Pak Yance is, yeah. Thanks for joining us. Pak Yance is a PhD researcher here at Leiden University at Van Vollenhoven Institute. He is also assistant professor at President University Law School in Indonesia and a former researcher at Huma and Epistema Institute. I mean, I'm sure many of you are aware of his book on constitutionalism agraria, which I read enthusiastically before. And this, our second presenter is Mbak Siti Rahma Mari Herwati, MA. Mbak Rahma is co-chair for knowledge management at Indonesian Legal Aid Foundation, or YLBHI, Jakarta, in Jakarta. Previously, he was the public defender at Semarang's Legal Aid Institute, who handled many cases related with land grabbing and environmental issues. Very important with to see her experiences on this. So thank you, Mbak Rahma, for joining us.
Thank you, Mas Ahmad.
Yeah, and then after that, we will have Professor Afrizal. Prof. Afrizal is a professor of sociology at Universitas Andalas in Padang, West Sumatra. I mean, we know, all of us know him. He is specializing in the study of land conflicts in Indonesia. Thank you, Prof. Afrizal, for joining us. And then we have Professor Ward Berenschot. Ward is a professor in comparative political anthropology at University of Amsterdam. And actually, we have another speaker, Pak Asep Yunan Firdaus. Pak Asep Yunan Firdaus has other responsibility to advocate local communities in one of land conflicts in Lombok, so he couldn't join us. But he is now working on access to justice in Indonesia in practice. And after that, we will have a discussion. We are fortunate to have Mas Norman Jiwan, who is currently an associate at Forest People Program and former director of NGO TUK, Transformasi untuk Keadilan Indonesia, an organization promoting social justice in the field of agribusiness and natural resource management. And he was also a former program officer at Sawit Watch. So he has a long experience on issues of land conflicts and access to justice in Indonesia. All right. that's for the introduction. Without further ado, let's start. Before that, if you have any question, you can keep it or you can start typing it in the chat section, and then we will discuss that later in the Q&A session. Thank you. All right, let's dive in. Let's hand over the stage to our first speaker, Pak Yance, who will present part of his PhD research on land conflict in North Sumatra, the indigeneity trap, limitation, and legal dispossession by cooperation. Thank you, Mas Yance.
Okay, thank you. Good morning and also good afternoon for everyone. Thank you for joining this panel, and also thank you for Mas Ahmad for the introduction. Also to provide a brief information about the land conflict in Indonesia, and I would like to present one case of my PhD research. Basically, I researching 3 cases. One in North Sumatra, in Banten, and also in Sumbawa. But in this moment, I would like to tell you about my case in North Sumatra, where Adat community have a land conflict with a pulp company, Toba Pulp Lestari. And yeah, so this is one of the interesting cases. I think it's one of example to understand how difficult is for local community to solve the land conflict with corporation. Yeah? And you know that land conflict is pervasive in Indonesia, and many local communities trying to use different narrative to deal with the land conflict. One of them is related to adat or customary, and then they're pursuing the state legal recognition as a solution for ending land conflict with the companies and also with state agencies. And so the big question that we will have to address for today is how effective is the legal system in addressing land conflict, and maybe this is one of example to deal with this question. Yes, so in 2013 there was the Constitutional Court decision reaffirmed the status of customary forests of indigenous communities in Indonesia. And this is one step forward to realizing the indigenous communities' rights over forest area. And 2 years after that, for the first time, President Joko Widodo invited 9 indigenous communities representatives to the presidential place. And then the president hand over directly some decree from the Ministry of Environment and Forestry to recognize customary forests. So this is like a very historical moment in the progress of Adat communities movement in Indonesia. One of the community that invited by the president at the moment is a community from Pandumaan Sipituta in North Sumatra. So different with the others community invited by the president, where the president hand over directly the decree to recognize customary forests of indigenous communities. But for Pandumaan Sipituta, the government released a decree to reduce a certain amount of companies' concession area to be designated to Pandumaan Sipituta community. They have a conflict with Toba Pulp Lestari before. And so in the 2016, the government allocated around 5,172 hectares of the company's concession to be designated. So this is not the final delivery from the government, but just to designated certain area from the company to be determined as customary forest of Pandumaan Sipituta. But before that can be delivered formally by the government, to formally recognized by the government, the community first should be determined as an Adat community by district government. Yeah. So that in that situation, that before the government recognize customary forest, the government has to ensure that the community is Adat community first. So they have to deal with the district parliament and also district government to encourage district government to create district regulation to recognize the Pandumaan Sipituta as an Adat community. So then this transform their identity from the Benjoin farmer before and become an Adat community. They're trying to work hard to push the district parliament to enact the district regulation, but they can manage in 2 years later, in 2018, that the district government recognized Pandumaan Sipitu Huta as another community. But that is not the end of the story, because then they have to apply again to the Ministry of Forestry to recognize their customary forest. And it is not easy step as well, because now until now the government, the Ministry of Forestry still has not recognized the customary forest of the Pandumaan Sipitu Huta, because they need to conduct verification and also delineation of the territory. The problem occurred because that what the community proposal is different with the allocation of forest from the company's concession area. This is I saw you in this picture that the yellow shape is the proposal from the community, because they have land conflict with the Toba Paplasari here, include especially here where when the violence occurred in the past. But then the Ministry of Forestry released different shape of the map. So the amount of the area is similar for 5,172 hectares, but the shape is different. And then the Ministry of Forestry adopt a map proposed by the company, not by the community. And this now still the conflict is not solved, because they need to deal with this situation. And then the Ministry of Forestry then also assigns amount of area from different communities, so it came to be led to the horizontal conflict if this map is enforced. So that is very complicated problem that happened in this case. And after invited by the president in 2016, it's not meaning that this case will be solved. Even after 4 years now, the problem is still not solved. So what the lesson that I can get from this case? The first, that what I found that in basically the conflict is the cause of conflict is the community against the company, yeah. But because they are asking, they're trying to follow the legal recognition of customary forest, and then the conflict is shift from the community against the company, but now it's the community versus the state, yeah. So they need to push the state to recognize the status and also the customary forest. The state meaning that the district government, also the national government through the Ministry of Forestry. The second that we can learn from here is the labyrinth of recognition. The legal recognition of customary forest is very long, complex, and uncertain as well. Yeah? So, for instance, when the community already obtained the district government regulation on the status of indigenous community, still not can be formally registered, because the district parliament have to consult with the provincial legal bureau, and the provincial legal bureau has to ask to the Ministry of Human Rights, Law and Human Rights, to ensure that this regulation can be enforced. So this very conflict, and it's very uncertain, and also this is out of control of the communities, yeah. So and also by NGOs, because this process is really depend on the discretion of the state officials, and by the end also make the community really dependent on the willingness of the government official. And then in the last visit to this location, and also come to different communities that also have a conflict with PT TPL. In the beginning, they're using also the adat rhetoric. They're using the legal recognition strategy to solve the land conflict. But then when I come them, this is from different communities, yeah. So they slowly, gradually change the strategy, yeah. So they're starting to working with the company. So they're starting to make a joint collaboration agreement with the company. But this is a strategy of the company as well, to divide it communities, and also by that so to give facility to the community to end the land conflict. But basically the solution is not everlasting. So in the current data, what I found that until 2020, the government basically has recognized 65 sites of customary forest, covering 35,000 hectares, but none of the legal recognition appear as a settlement for land conflict between other communities and corporations. So for the 65, there are legal recognition of customary forest, but not as a solution for land conflict between communities and corporations. For the 65 is a land conflict. If there is a conflict, is to solve land conflict between communities and national park, for instance, and other type of land conflict. So what I found that when the community have a land conflict with the company, when they're starting using legal recognition as a solution, it can be very, I mean, it's not a promising solution. So maybe it's good to think another strategy if the type of the conflict is between communities against the corporation. It's different with one of my case as well. It's quite successful because the conflict is not between the community with the company, but the conflict between the community and the national park. So that is different story that can be so the effectiveness of the other strategy to solving land conflict. So I return to yeah. So that is my presentation, Mas Ahmad. I'm looking forward to receive question later.
Yeah, thank you, Mas Yance. Very fascinating study on land conflicts in North Sumatra, which is very and also involve adat issues. Yeah, and we can see from even from short presentation how complex is conflict when we want to resolve land conflict, forest and land conflicts in Indonesia. And this leads us to the next presentation. We will have another example of obstacle for access to justice from Central Java, from Mbak Rahma. Mbak Rahma will present the findings of her research on land conflicts in Central Java, how peasants' land right claims over state plantation company in Central Java based on her thesis. So, Mbak Rahma, time is yours.
Thank you, Mas Ahmad. Good morning and good afternoon for everyone. Yeah, actually, this is, should I share my screen or?
Yes, please. Yeah.
Or Mas Ahmad will?
You can, yeah.
Yeah, all right. Yeah, the title of my presentation is Peasants' Land Right Claim over a State Plantation Company in Central Java. Actually, this is based on my advocacy work when I was in the Semarang Legal Aid Institute in 2000 until 2011, and also become my master thesis as well. Relating to the State Plantation Company, actually, this is one of some biggest cases on land conflict in Indonesia recorded by Indonesia Legal Aid Foundation, and the PTPN 9 in Kendal district is one of them. And the PTPN 9 is a state plantation company. It has a 420 hectares wide area, and it appeared in 1957 when Indonesian government conducted the national policy in that time. And actually the national policy nationalized all of the Dutch or foreign assets such as plantations, buildings, housing to be under Indonesian government control. And also this has happened in this village when the nationalization process also impacted to the peasants' land because it was taken over by the government to become state plantation. Therefore, my questions will be how was the peasants resistant in this case, also the state response, and the final verdict of the Supreme Court, and also the impact to access to justice for the peasants in this village. This plantation is for rubber and coffee plantations, and actually peasants in this village opened the forest, the land forest, for the first time in 1930s. and they cultivated the land with crops. And how was the land conflict began between the peasants and the PTPN9 in 1957? At that time, the peasants in this village, they received a warning letter from the state plantation company, which is banned the peasants' access to their own land. And the letter itself, it was signed by military and then military authority and also the local government and the company's representatives. It stated that the peasants had occupied the lands illegally according to the wartime local authority regulation 1957, and that after that, the peasants have to out from the land, and finally the peasants lost their land after that until 1998 during the reform era, because during the new order they did several effort to gain the land back, but it fails during the new order, and they find the momentum in 1998 in the reform era, and assisted also by the Semarang Legal Aid Institute and Indonesia Legal Aid Foundation, the peasants established a local peasant organization. They start to lobby to the government and also land institutions agency. That they also got support from a local parliament commission to recommend the peasants to cultivate the plantation land. And also the peasants make a collaboration with other peasant organizations and NGOs. They start to complain to the Ombudsman, National Human Rights Commission, and also complain to the Indonesian National Police because of the intimidation by the company. And they finally reclaim the lands. Because of the reclaiming lands in 1998, 1999, and the company and the state responses to the reclaiming land of the peasants. The first one, they criminalized the peasants. They also deploy the police in the plantation land, deploying the plantation workers, intimidate the peasants, and also destroying the plants. And finally, they used the court to evict the peasants. So this is some of the state apparatuses at the local and also the national level, like a local parliament. They facilitate the negotiations between the company and also the peasants. And the National Land Agency, after they got complaint from the peasants, they take to remeasure the land. But the final result of the remeasuring the land was disappointing because the wider area of the company is wider than before. And also the Indonesian National Police, they keep on backing up the company. They don't take anything, then don't take action, anything about the intimidation to the peasants. And because the company filed a law case to the district court and the high court, the district court decided that the peasants were lost at that time. And the peasants then appealed to the high court, and this is the same result in the district court, because the appeal in the high court, they also lost at that time. And in 2005, the peasants appealed to the court, Supreme Court, and in 2010, the Supreme Court accepting the peasants' appeal without considering and deciding the ownership or status of the disputed lands. Indeed, it revoked the High Court verdict by rejecting all of the plaintiff lawsuit and stated that the company had no legal standing to file any lawsuit. But the legal status of the disputed land is not decided by the Supreme Court. While on the other hand, the right of the commercial cultivation by the company has ended in 2005, and therefore, according to the Indonesian law, it's back to the state land and must be redistributed to the peasants. But up to now, the company is still occupying, controlling, planting, and also intimidating the company, deploying plantation workers to intimidate the peasants and also to evict the peasants. Well, the company uses the legal status as a state plantation to occupy the land without being interrupted by the state. Even the National Land Agency contends that although the company's right has ended, but the land still belongs to the state or company as state asset. That's why even though the Supreme Court decision has issued and also the right of commercial cultivation by the company has ended in 2005, but until now, regarding this is recognized as the state asset, then the peasants in that village, they cannot get access to justice to their land. That is my presentation. I think. Yeah, thank you.
Yeah, thank you, Mbak Rahma. Another fascinating case from Central Java, which shows really clearly about legal obstacles of how community to reclaim their land. And also, yeah, and not only sometimes not only about the court verdict, but also how it can be implemented on the ground is another question. And that leads us to the next presentation. We will have Prof. Afrizal and Ward, who will present some of the findings for a research project on palm oil conflicts and access to justice in 4 provinces in Indonesia. Yeah, Ward, please.
Thank you very much, Ahmad. Ward Beresford and me, Afrizal, will present our research project collaboratively done with Hoto Space from Wageningen University and 4 NGOs, one in West Sumatra, Walhi West Sumatra, and then one in Riau, Scale Up, then one in Central Kalimantan, Walhi Kalimantan, and one in West Kalimantan with Gamawan. I will present the rationale of our research, and then Ward will present our findings. Yeah, why we do this project? So far, land conflicts are studied through scattered case studies. Yeah, hundreds of case studies about land use change conflict has been done in Indonesia, including by me and also by Yance and others, and also Ahmad. So a collaboration of KITLV, Andalas, Wageningen University, and also NGO set out to study a general pattern. So we lack of knowledge about general pattern of land use change conflict. What causes of the conflict, what people claim, what they want to have, what the reason, how they do it, how the conflict will resolve, what the solution has been achieved. So to this end, a team of in total 19 researchers documented the trajectory and outcome of conflict between communities and palm oil in 4 provinces. West Kalimantan, Central Kalimantan, West Sumatra, and Riau. We developed first what we call it a template for describing a case, and then we teach the 19 researchers how to use this template, and then we have what we call it a midterm workshop to monitor what has been done, what problem they encounter. Then we caught the cases, and we manage a quantitative data about it. In the end, 150 conflicts were successfully documented using a wealth of materials, interviews, newspaper articles, government and NGO reports, including interviews to the village where 150 cases occurred. So in this presentation, we use this material on 150 cases to evaluate the effectiveness of conflict resolution mechanism. So our big question is how successful are available mechanism to resolve land use conflict, including newly established RSPO conflict resolution mechanism. Ward, it is your turn. Thank you very much.
Yes, good morning, everybody, or good afternoon. It falls to me to present to you quickly some of the results of that research that Afrizal presented. And it's kind of the first time. So this is a first glance that we can give of what we found in those 150 cases. And we don't have much time, so I'm going to really run you through it and focus really on access to justice and how good particularly conflict resolution mechanisms are. First of all, a little bit what communities do when they are faced with conflicts. One interesting pattern here is that not just that they do a lot of demonstrations, but they generally target not the company, but local governments in order to get their support through these hearings, which are also very common, in order to get the local governments to help pressurize the companies, as well as engage in mediation. I'll get to that. Not much violence, which struck us, actually. Communities are not that violent. It's more often the police actually is more violent than communities. And then what mechanisms do people turn to address these conflicts? So actually, and this is just data from Central Kalimantan, but the pattern is common. Basically, mediation or facilitation of interaction by local authorities is most common, and courts only turn to in about 24% of the cases. So formal mechanisms are relatively rare yet, while these concern very important conflicts. And that is also a reason why according to us, communities are relatively unsuccessful in dealing with these conflicts. So we asked all our community representatives to indicate to what extent they achieved their goals. And here you see the result going from no success at all to we fully achieved our aims. And basically the summarizing statistics of this broad paragraph is that this broad table is that about in 2/3 of the cases, about 66%, communities achieve no result or barely a result, meaning like a token thing, some CSR money. So actually, while we are discussing a phenomena that leads to demonstrations and hearings and a lot of contentious politics throughout Indonesia, communities are very unsuccessful in achieving their goals. So why is that? Partly, we argue that it's because of the relative uselessness of courts. Communities go to courts relatively little. They distrust them. They also, partly Jantje touched upon that, the legal framework is really not at the advantage for communities. They make it difficult for people to use the court because people have it, it's not easy to prove land ownership. But also we find when they do manage to get the money and the energy and the time to take cases to court, they are often refused or they have a negative ruling against them. And out of those 10 rulings in favor of the communities, we found a similar pattern that Mbak Rahma just mentioned, that even when they win up into the Supreme Court, in 3 out of these 10 cases, the rulings are not implemented, which is quite a serious problem, that somehow the enforcement of rulings is a problem. Now, that means that basically mostly communities turn to informal mediation. They ask particularly local authorities, you see them here, the Bupati or DPRD politicians, and often also like local civil servants, like particularly the Camat, to mediate between them and the company. And that is also relatively unsuccessful. Again, I think about 70% of the mediation attempts fail, or they lead to an agreement but is not implemented. Only we found when we look at our overall data, when you have a professional mediating NGO or professional mediators involved, they have a much higher success rate. But when local authorities are involved, they generally fail. So that research leads us to, currently we're in the process of launching several policy briefs to convey, to translate these findings into a number of policy recommendations that we feel this data calls for action from local governments to improve conflict resolution mechanisms and access to justice. Currently, these conflicts simmer on for years. On average, we counted about 12.5 years at least. And there is a lot of things that can be done to improve this. And we mentioned 4 of those things here. Stop criminalization of protest leaders, impose sanctions on companies that are not unwilling to cooperate in conflict resolution mechanisms, institute a mediation board to provide a new, more effective mechanism. And yes, the broader topic always, but the legal framework related to land in Indonesia is inadequate to deal with these conflicts. I'll leave it at that.
Yeah, thank you, Ward and Prof. Afrizal for sharing the findings from research project on palm oil conflict and access to justice, which actually show more on how actually the existing conflict resolution mechanism, either court or in more informal mediation, other things are not currently quite effective in resolving land conflicts in Indonesia. So it leads us to the further discussion from Mas Normanjiwan. And we have fortunate to have Mas Normanjiwan here to provide some reflection on previous presentation, basically to what all these findings mean for overcoming the obstacle of access to justice in Indonesia. Mas Normanjiwan, maybe hopefully in 5 minutes. Thank you.
Thank you very much. I'm late because I just attended a court proceeding in Sambas. Asep is one of the lawyer in that case. This is the first case in West Kalimantan where indigenous peoples community suing the HGU of the company. So they try to challenge because the HGU is clearly illegal. The name of the location mentioning about different village, but the HGU is applied in a different village. So it's we believe that legal in legal perspective, it's clearly wrong. HGU was issued 2 days before SBY, the previous president's. My reflection. Thank you very much for the presentation. Very interesting. To see that how deep analysis made by our speakers and our researchers, especially the trap of indigeneity, is very clear from my point of view. There must be an FPIC-based process. That is one of the requirements that, from my point of view, very important. Not only for the private sectors, but also for the state-owned plantation company, whatever the company, in forestry sector, in natural resources sectors, peasants, or indigenous peoples. The very basic principle of free, fair, and informed consent is very, very much important, because the process itself, it empowers not only the owners of the land, but at the same time, if it gives the opportunity for the government, the company to provide information relevant to what are the rights of the people from legal framework, national and international perspective. That is what I think it's very important to be there in place when we are talking about access to justice. That is why one of the cases that brought forward under the compliant ombudsman advisory of the World Bank, Wilmar cases, is one of the cases that where the community is really getting access to justice. They can get their land back under the process of the conflict resolution mechanism that is mediated and facilitated by the World Bank. And that is the first point. FPIC must be there, a very basic principle and basic process that a company, both company, either state-owned plantation company or private company, they are hold accountable to be fair and to be in a process that the community have the opportunity to be empowered. And other cases is also, I think, the issues of power balance is very much relevant to the all cases and all issues, especially when it's come to implementing the ruling or the decree even by the president itself. There are many good examples in West Kalimantan. They have already what they call local regulations on the protection and recognition of the indigenous people's right. But that local regulation, legislative act is not enough, because if the community is not pursuing for that recognitions and legal recognition for their own status of indigenous people, full stop, you will never been able to get that your right properly. Only one good example in Sungai Uti is because they have been struggling for about 40 years, and they can get all the proper indigenous territory, 9,000 hectares, being excised, not excised, really returned back to the Sungai Uti community, that is Iban community in West Kalimantan. I think that is one of good example. But in that context, you cannot do in other province where forest areas is below than 30%. Because when you want to release indigenous claim from a state forest, if it is already below 30%, it is impossible. The government is not going to release that. In Kapuas Hulu, the state forest is still around 50% or almost 60%. So it's still possible for the forestry to release that forest areas. And I think my last comments is more about Indonesia have been, when we are talking about judiciary system in Indonesia and access to justice system in Indonesia, we don't have a good best practices, especially when we are talking about why there is no FPIC best legal implementation process in Indonesia. So that is a big question for us about talking about how we can, my last point will be how we can empower people to really accelerate access to justice. I have never heard about any research about what is and what can be done to develop a strategy that can accelerate access to justice. So we people keep on talking about access to justice, but forget about what is the best strategy to accelerate access to justice. Those are my comments that, from my point of view, are very important strategies. And my last point, after the passing of Omnibus Law, we have to rethink everything that we have been doing, and will be doing in the future, because this is a new destroying gun that will just destroy everything about human rights, environmental rights, indigenous people's rights, because almost none participation from indigenous people, local communities, peasants, environmental activists, and others group that concerns with their legitimate works actually accepted and considered properly. in the omnibus law process itself. That is last challenge, also open question to all of us here about the strategy after omnibus law is passed. Thank you.
Okay, thank you so much, Mas Norman, and all are very important points, and also you also give a very important question as well that we may need to discuss, and it will be good if we get that answer during this discussion Q&A. So after this, we will go to Q&A. Before I read a question from our audience, but I think because Mas Norman started with a very important question, and shall we? I mean, some questions are for Afrizal and Ward, but maybe from Mas Yance and Mbak Rahma maybe can comment on the question from Mas Norman about how to empower people or how to accelerate access to justice in Indonesia. What's the best strategy will be? Would you like to share some insights on this question?
Yeah, actually, thank you, Mas Norman and also Mas Ahmad. I think that there are some strategy that we can do, but basically we have non-litigation procedure and litigation procedures. So this is like for non-litigation procedure, usually we have to empower people first. We have to empower a farmer or peasants first for their rights. So they have to know what is the claim, and also the basic claim that they have. And after that, they can take another step after they empower themselves to build a local organization for farmer, and they can make a negotiation. They have to take many support, as many as they can, from the local government and also the parliament, the academics, also the journalists, and also the non-governmental organization, and also the other local farmer organizations. They have to work with them and then make a campaign for their rights. Basically, all of the land conflict in Central Java, if YLBHI try to solve them, have to solve outside the court, because this is considering the evidence owned by the farmers is very limited, and usually it was destroyed in the past, in the 1950 to 1960, because of the issue of the communists, many things. And that's why the litigation procedure is the last effort that we have to take after all of the non-litigation procedure we take, and that this is fair, and that the final will be a litigation procedure. I think that's my question.
Yeah. Thank you so much, Mbak Rahma. Mas Yance, would you like to add?
Yes. Yeah. Thank you. And also thank you for Bang Norman for very excellent comment. I think it's also very important for us to reflect on the regulation of environmental law through omnibus law, for instance, also the regulation of protection of local people's rights. Yeah, because when we see that in the omnibus law in Indonesian legislation currently, very lack of the guarantee of FPIC. So if we compare that, for instance, if we compare RSPO standard with Indonesian legislation, yeah, I think it is better to see that the RSPO standard is better than Indonesian legislation. So how do we can rely on the very weak legal framework to ensure access to justice? So I think it's raises a question whether we need to more engage with the market regulation, because the market also changing. Yeah, for instance, UN released UN guideline for business and human rights, many certification standard, and I think it's a new way for the activists and also for activists to really trying to learn how to approach conflict. It's not only rely on the state law, because the state law is regulation, but how to really understand how to utilize the non-state mechanism to solve land conflicts. That is the challenge, I think, in Indonesia in the future time.
Thank you, Mas Yance. Very great point. It seems that both Mbak Rahma and Yance, we need to have alternative for resolving these disputes. Yeah? But there are some questions also about this, especially related with presentation from Afrizal and Ward. There is a question here and a statement from Santi. First, 10 cases won by communities is a big improvement actually to her findings for cases on land right in Supreme Court in 2009. And there is also a question from Adrian for Afriza and Ward. How do you define conflict resolution and what do you mean by success? Yes, so would you like to address that?
Let me first answer and then Ward. What we mean is conflict resolution is a mechanism of resolving conflict. So that's what we mean. Because I know that in literature there's a confusion. Some literature are confused between conflict resolution and conflict solution. So so I want to say it again. What we mean with conflict resolution is a mechanism of resolving conflict. Thank you.
Yeah, but another question: what do you mean by success? Or what? Feel free to add. What do you mean by
it is very tricky one. It's very difficult to measure a success, and therefore, in our study, we ask people to measure themselves what they mean successful resolution, and of course, we can also provide objective measurement of successful conflict resolution. But as what mentioned earlier, we prefer asking people to measure themselves to successful conflict resolution.
Yeah. Yep. What do you want to add something? And also, maybe you can also want to comment on this from Winner Conference then.
I see there's a
regarding
question on the mediation board.
Yeah, maybe you can also add as well, please. Thanks.
Yeah, I'll try to take up some questions altogether. Thanks for all these questions. Starting with Norman's questions about how can extra justice be made more effective. And I feel the efforts there should really go towards strengthening mechanisms of conflict resolutions and engaging collective actions as organizations to push the government to provide these mechanisms. Right now, a lot of the NGOs that I've been seeing and working with focus on training communities, provide them skills, give them strategies. But as Rahma also kind of implicitly said, once they have all these skills, still they have nowhere to go, where to take their case, because the courts are inaccessible, expensive, legal problems, etc. And these mediation mechanisms that we highlighted, they are riven with exactly the kind of power plays that this Winner Conference person mentioned, that usually the people mediating the conflict, they depend also on these companies for campaign finance money, for example. So there is at present really no mechanism. And that is why I think there's a need to push local governments to set up independent mediation boards with independent people that do not depend on either side, and that are trained in doing multiple rounds of mediation. And that is there's a real need for this, given how lack of perceived success from communities that they feel, as we studied, they feel they are not succeeding anything even after 10, 20 years of struggle.
Yeah, thank you.
That's it.
Thank you, Ward. And there is another question for Mbak Rahma regarding from Adrian about what's the legal basis for the land claims of the peasants in that case, and how this affect the conflict resolution outcomes.
Yeah, thank you, Adrian. So there are some land rights contained in the Basic Agrarian Law, number 560. One of them is right to clear land, right to open land. And actually, the peasants in that village, they clear land in 1990s and should be recognized by the government. And in 1950, they got like a text letter in Indonesian language, petuk pajak. Yeah, this is a letter proof that the peasants cultivate the land. And before the release of the basic agrarian law, this is quite strong evidence for them. And after 1990, after the issuance of the basic agrarian law, it should be registered as a land of ownership, right to ownership. So this is the similar strength to the right to ownership. So they got both of them. They got them, and but before they registered the tax letter to be a right to land, right to ownership, and then all of the letter were taken by the company, and then at the time it was disappeared because it was taken by the company at the time. So there is one or two letter left, and it will be kept by the peasants until now, but it cannot be the evidence in the court at that time because they found the letter after that, after the court process finished. So they got the tax letter for their cultivation land. Okay, thank you. Yep.
Thank you. I hope that answers all the questions. Yes, okay, there's another comment from Adrian. The problem of success is that from the perspective of the companies, the cases are resolved very successfully. Yes, I think that's also another important point about which perspective that we use in assessing the success. And do you want to comment on that?
Briefly, I'm not sure how much time we have left and how strict our winner bosses are, but I'll just to respond briefly. I see where Adrian comes from, but actually, these palm oil conflicts are a major headache for the palm oil industry as well, and the fact that they linger on for years do great damage to the industry, with including not only obstruction of the operations, but also the image of the industry abroad, which leads to people buying palm oil-free products, etc. And just think about the recent fight with the EU. So I think it's also in the interest of the palm oil industry to find more effective mechanisms to solve them, and to really support ideas like this one about instituting a mediation board locally to complement the efforts of the RSPO, which, as we found in our research, they are usually too far away for communities to turn to.
Thank you, Ward. And I think we already passed 6 minutes past our deadline, but I think if I may, I want to have one last question from Mas Norman question actually. What if any of our speakers or even Mas Norman himself want to comment on what do you see the future after Omnibus Law in terms of access to justice? Maybe that can be interesting to if anyone has a view, like Mbak Rahma or Mas Yance or Prof. Afizal or what. Would anyone?
Maybe I will try.
Yeah.
Omnibus Law. Some of the basic agrarian law principles or philosophy have been destroyed by the Omnibus Law. Even though Omnibus Law didn't state that they changed the basic agrarian law in that bill, but the philosophy and also the perspective and the basic norm of the basic agrarian law have been destroyed. And that's why if it is implemented, it will be disaster for the farmer or indigenous people as well throughout Indonesia, because they will get attacked from the corporation, from the government itself. There is no land rights for the farmer because of the implementation of land banking, and then many things, certification, and then criminalization against farmer, and also land acquisition. and also spatial planning will not involve them as the victim in the process of the development. I think that will be worse.
Yeah, thank you. Thank you for your insights. Anyone want to add on that about regarding what do you see access to justice after omnibus law has been issued? Okay, if there's no other comments, I think we reach our the end of our. Sorry, yeah.
Ahmad,
Yes.
Omnibus law gives greater authority for the central authority, central government, especially for the centralizations of the permit system, licensing system. So it's creates a far distance and border and access to justice for not only indigenous people, but ordinary people, because all the permit system are centralized in Jakarta. So even when you are a business person, apply for a very significant and very important nuclear power plant, for example, that is very dangerous idea. It used to be, has to go through strategic environmental impact assessment at the provincial level and national level. But now you just apply to the central government. If your business possibility is okay with a profit promise is higher, and with a very good calculations about the perspective of the business, so you will be accepted. And then the process of the approval, it's now going to be involving indigenous peoples and local communities, and no FDIC at all in a centralized permit licensing system. So that's very dangerous. I mean, that's why what Rahma said is actually, it's already happening in the past, but now it's going to be worse. Thank you.
Yeah, thank you, Mas Narwan. I think I agree with all your points. That it seems that many people are worried now with the new omnibus law. That it seems that it will get worse. But yeah, thanks for. I would like to close this with.
Maybe I would like to add, indigenous peoples and local communities are now submitting a report together with Friends of the Earth Indonesia, Huma, and Aman just filed a complaint against Indonesian to the third committee on the elimination of racial discriminations. They calling for the government to revoke this and reveal this omnibus law to the United Systems. Thank you very much.
Oh, thank you. Yeah, it's great to hear that. Yeah, hopefully it will be successful. And yeah, thanks. I would like to close this with big thanks for all the speakers who has been very excellent in discussing our topic today, and also for Mas Normanjiwan for giving very deep insights on this topic and giving us, and also I would like to thank all the participants and all the questions. They all are very, very good questions. I hope we already covered all the questions, and I hope, yeah. But before we close, there is a question from our organizer, which I also should thank. Thank you for winner organizer, very excellent in organizing this. We want to take pictures, maybe for the winner website. I don't know how the technicalities of doing this. Maybe from the winner organizer.
Someone has to take the picture.
I think from winner organizer will take the picture.
Yeah, we have to take a picture, and you have to turn on your video all for the participant too.
Yeah,
all already active.
Yeah, for
but the participant is not active not yet.
Yeah. Okay. Yeah.
Hello, Norman.
Wait a minute, right?
Hello, Prof. Afrizal.
Long not to see you.
A long time no see.
Untuk partisipannya bisa diaktifkan kameranya.
Yeah, if you feel convenient, would you mind to turn on your camera?
All participants, yeah.
all participants. Yeah, please.
Wait.
Okay, maybe yeah. Maybe yeah.
Okay.
More.
More.
More. It's less than 23 participants, I think. Participants are 23, I think. Yeah.
Okay. Yeah, maybe some people are not. Yeah.
Thank you, guys. I finished to take a picture.
Oh, you finished? Okay.
Yeah.
Okay. Thank you so much again, everyone, for joining this session. I hope we will meet again soon in other session. Thank you so much for Winner Conference for organizing this.
Thank you, Ahmad. Thank you, Ward. Thank you,
everyone.
Rahma, and all.